Welcome to literary and jury charge practice. We'll start out with some literary material. This is called Building Trust. After a natural disaster, beware of unscrupulous contractors. And we had actually started this before, so we will just continue on where we left off. Ready? Here we go. And insist upon seeing the contractor's license and proof of insurance. The contractor should have both general liability and workers' compensation coverage. Get a written estimate and a signed final contract. Both should specify in detail the work that will be done and the materials that will be used. They should also provide a breakdown of the prices for labor and materials. Be smart about payment. It's reasonable for a contractor to request a down payment for materials, but never put down a large amount until the contractor arrives on site with the materials to start the job. In California, the State License Board limits down payments to 10% of the total home improvement contract price, or $1,000, whichever is less. Paying by credit card could give you some options should you need to stop or contest payment. And by all means, do not pay the contractor in full until the repairs are completed to your satisfaction. Don't hand over money to people claiming to work for government agencies. Legitimate state and federal workers should never ask you directly for money as compensation for performing inspections or filling out forms. And if you're told that you can get your insurance settlement or disaster relief funds faster if you pay a fee, don't believe it. No one on the up and up can accelerate the process. Sign a contract without reading it thoroughly. Make sure the agreement includes a dollar figure and that your insurer is okay with the estimate. Give your social security number to a contractor. No one needs it except the government agency that's providing your disaster relief funds. You'll only need to provide it once, when you first register with the agency handling the funds. All right, let's practice some jury charge. Ready? Here we go. You are the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect. In determining believability and weight of testimony, you may take into consideration the witness's interest or lack of interest in the outcome of the case, relationship to the parties, ability and opportunity to know, remember, and relate the facts, manner, age, and experience, frankness and sincerity, or lack thereof, reasonableness or unreasonableness of their testimony in the light of all the other evidence in the case, any impeachment of the witness's testimony, and any other factors that bear on believability and weight. You should rely in the last analysis upon your own experience, good judgment, and common sense. A witness who has special training, education, or experience in a particular science, occupation, or calling is allowed to express an opinion as to certain facts. In determining the believability and the weight to be given such opinion evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness, the reasons given for the opinion, the sources of the information, and the factors previously given for evaluating the testimony of a witness. Such opinion evidence is entitled to neither more nor less consideration by you than any other evidence. You are to judge its believability and weight in the same manner as you will do for evaluation of other testimony. In deciding the believability and weight to be given the testimony of a witness, you may consider evidence of a statement by or conduct of the witness on some prior occasion which is inconsistent with present testimony. Evidence of any prior inconsistent statement should be considered only for the purpose of testing the believability and weight of the witness's testimony. In the case of defendant, however, evidence of any statement which he may have made may be considered by you for all purposes. The state must convince you by evidence beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant has no obligation to prove innocence. The defendant has the right not to testify. This right is guaranteed by the federal and state constitutions. You should not draw any inference from the fact that the defendant has not testified in this case. In this case, the defendant has been charged with multiple offenses. You should consider each offense and the evidence pertaining to it separately. The fact that you may find defendant guilty or not guilty as to one of the charged offenses should not control your verdict as to any other offense. During trial, you have listened to audio recordings. Because of the nature and quality of the recordings, portions of the recordings may have been difficult to hear or understand. As a result, transcripts of the recordings were provided to you to assist you in listening to the recording and were collected from you at the conclusion of the playing of the recording. If there is any difference between what you heard in the recording and what you read in the transcript, then you must rely on what you heard, not what you read. The transcript is not to control, rather, the recording which you heard is to control. The transcript will not be available to you during your deliberations. The parties have introduced demonstrative exhibits in the form of charts, summaries, or calculations. This information is presented to assist you as an aid in your understanding of witnesses' testimony here in court. Rest your hands for a moment. All right, let's try this literary material. It's called Back to the Farm. Ready? Here we go. You can probably find your local farmer's market, but would you know what to do if confronted with an actual vegetable patch? Scotty Jones, co-owner of Leaping Lamb Farm in Alessa, Oregon, says most people don't. I've asked guests to go out to the garden and pick something for dinner, and then realized that I needed to go with them because they didn't know what to do, Jones says. Such farm-to-table experiences are a growing trend among working farms, with many opening their doors to overnight guests. Rates run about $125 per night. Following are a few reasons to visit a farm. Taste something fresh. The biggest surprise out here for people is the flavor of fresh eggs, and I love seeing their reactions, says Jones, whose 64-acre sheep farm includes vegetable gardens, orchards, and chickens. Many farm stay farms give guests access to the garden's kitchen and farm-cooked meals. Learn more about the food you eat. Milk a goat, then make some cheese at the tiny Mariposa Creamery in the foothills northeast of Los Angeles. The Institute of Domestic Technology offers a bushel of food crafting classes there, and the Milk Talk from Mariposa co-founder Gloria Putnam will give you a new view of dairy products. Appreciate farmers. Watch or help with the harvest at Humble Hill Farm outside Ithaca, New York. Then follow the goods to market. It's definitely not an easy profession, says co-owner Courtney Sullivan. It's important to tell the story of the people who choose to dedicate their lives so that you can have healthy organic food. Support small farms. When we moved here, we didn't really understand the economics of small farms, Jones says. She opened Leaping Lamb to guests to help pay the bills and launched the Farm Stay US website to connect host farms with vacationers. Farm stay fees are helping Putnam and her partner expand Mariposa Creamery. Accommodations range from tents to guest cottages to Mariposa's little Airstream Bambi. Guests can help with farm chores or just soak up the peace and quiet. It's all part of the farm stay experience and preserving farming for future generations. All right, we'll get back to some jury charge practice. Ready? Here we go. If the chart, summary, or calculations are not consistent with the facts or figures shown by the evidence in this case as you find them, you should disregard the chart, summary, or calculation and determine the facts from the underlying evidence. Additionally, because the charts, summaries, or calculations are based on the testimony, you should therefore give them only such weight as you think the underlying material deserves. The statutes of Minnesota provide that whoever with premeditation and with the intent to effect the death of the person causes the death of a human being is guilty of murder in the first degree. The elements of murder in the first degree are: first, the death of Nicholas Brady must be proven. Second, the defendant caused the death of Nicholas Brady. Third, the defendant acted with the intent to kill Nicholas Brady. In order to have had an intent to kill, the defendant must have acted with purpose of causing death, or the defendant must have believed that the act would have that result. Fourth, the defendant acted with premeditation. Premeditation means that the defendant considered, planned, prepared for, or determined to commit the act before the defendant committed it. Premeditation, being a process of the mind, is wholly subjective and hence not always susceptible to proof by direct evidence. It may be inferred from all the circumstances surrounding the event. It is not necessary that premeditation exist for any specific length of time. A premeditated decision to kill may be reached in a short period of time. However, an unconsidered or rash impulse, even though it includes an intent to kill, is not premeditated. Fifth, the defendant's act took place on or about November 22, 2012 in Morrison County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of murder in the first degree. If you find that any element has not been proven beyond a reasonable doubt, the defendant is not guilty of murder in the first degree. The statutes of Minnesota provide that whoever with premeditation and with the intent to effect the death of the person causes the death of a human being is guilty of murder in the first degree. Second, the defendant caused the death of Hale Kiffer. Third, the defendant acted with the intent to kill Hale Kiffer. In order to have had an intent to kill, the defendant must have acted with purpose of causing death, or the defendant must have believed that the act would have that result. Fourth, the defendant acted with premeditation. Premeditation means that the defendant considered, planned, prepared for, or determined to commit the act before the defendant committed it. Premeditation, being a process of the mind, is wholly subjective and hence not always susceptible to proof by direct evidence. It may be inferred from all the circumstances surrounding the event. It is not necessary that premeditation exist for any specific length of time. A premeditated decision to kill may be reached in a short period of time. However, an unconsidered or rash impulse, even though it includes an intent to kill, is not premeditated. All right, we will stop there, and that will conclude our literary and jury charge practice.